Tamale Central. Thank you, Alhaji, for speaking to us. Good morning to you.
Good morning, Sarah. How are you?
I am doing well.
And how is Madam?
She's fine.
Because now you are not alone. I'll need to talk about it on radio so that some of your numerous girlfriends will hear.
Alhaji. Alhaji, how's Tamale?
Well, Tamale is not bad.
The rains are helpful?
Yeah, okay. So climate change situation is not coming as expected, but well, we are managing.
See. Well, Alhaji, this morning I called you to have to ask you your own views on. I don't know if you've been able to read the judgment, but at least you have an idea what the court has decided on this matter of the tape that we've all listened to. The Attorney General had a conversation with Mr. Richard Jackman. What do you think?
Yeah, so first of all, I think that having referred to the judgment, a friend sent it to me yesterday, a brother. Well, I think that I owe him a debt of gratitude. I finished reading the judgment is in two parts. The judge divided the judgment in two parts, dealing with the two accused persons. So I finished reading with that of Atu Folsom. I'm yet to read that of Japa. Now, but generally, what the judge sought to do was to navigate the narrow confines of the law and try to exercise a jurisdiction in a rather very difficult circumstance. And you could see it in her analysis of the situation. The law is a conservative profession, and so, especially in criminal matters, criminal law 101, everybody knows that if a crime is not provided in a statute, or if a procedure for a crime is not provided in a statute, it's difficult for a lawyer, counsel to invoke the inherent jurisdiction of the court to try to infer into a procedure which is not provided by law, or drive the crime by inference which is not provided by law. So you could see clearly that the judge was navigating a very narrow confine, even though the judgment has been very revealing.
So there's a difficulty created by the kind of system we have.
Yes, the conservative system, which is largely akin to practices of the law in common law jurisdictions.
But I said this is very revealing. Explain, and what are the observations you made?
The judge had a very dim view of the conduct of the Attorney General. She called the conduct reprehensible and came to a firm conclusion that there was professional misconduct. And even though she said clearly that she didn't have jurisdiction to order an inquiry into the conduct of the Attorney General, she thought that if the applicants were minded to pursue the professional misconduct of the Attorney General, there was another administrative avenue, which is the General Legal Counsel.
And do you agree with that the General Legal Counsel is the best platform for this?
I had said that on your network. Not the best. I said one of the best avenues, even though I was constrained to say that that's the best because the Attorney General is a member of the General Legal Counsel.
Which other avenue can they use?
The Parliament.
Parliament?
Yes.
What will be the objective of using Parliament? What can Parliament essentially do?
Because Attorney General is a creation of the Constitution. It's a constitutional body. He's not gone out of his way to do things that can be properly so-called constitutional breaches. But he has acted in a way that brings his office into disrepute. And so Parliament can initiate a couple of motions. A motion of censure is one. Conduct an inquiry into his conduct is two. Because of the public interest in the matter.
What would be the ultimate objective of that? Because what you have said, you said
The ultimate objective is to bring sanctity into to the office of the Attorney General to ensure that future Attorney Generals will know. So it will result in his removal, and then the future Attorney Generals will know that you cannot misbehave while you are in that office.
And what about the law? Because as you speak, you're saying that the law has created narrow confines for the judge. Do we need to expand our law to include things like mistrial and
there's
others?
No mistrial. There's no mistrial as a concept in the laws of this country. The nearest is a retrial, and that is on indictment, or what we call jury trial. And so, if we really think, and I sympathize with the counsel for the first accused, because the combined effect of reading the provisions of fair trial and presumption of innocence clear will lead you to the understanding and appreciation of the fact that if a prosecutor who is not interested in the justice of the situation, but only seeking a conviction, tries to procure evidence from one of the accused persons to be used against another accused person in the same criminal trial, that could be a mistrial.
Now let's come to the Attorney General himself. So far, 2 public comments. The first one that they've set many traps for him. The second one is a feeling of the fact that he's been vindicated, sort of. That the accused persons have lost all their applications. He's not going anywhere.
Vindicated. So I think this is the one first. He's not been vindicated. The subject matter of the public Ferrari on the engagement, the tape recording that was played to the public, is that people came to the conclusion that if the Attorney General really did that, then that was misconduct. It was seriously described as gross misconduct. The court calls it professional misconduct. So that has been upheld in the court. And so, if indeed it's professional misconduct, can the subsequent action of ordering an inquiry into his conduct, or ordering a mistrial, or stopping or preventing or truncating the prosecution of the case, can they be founded on the professional misconduct? That was what the lawyers for the accused persons went to court to try to persuade the judge to take a dim view of what the Attorney General has done, and also to give them their reliefs. Now the court took a dim view of the Attorney General's conduct, but said it didn't have jurisdiction to do the things that they said they wanted him. They wanted the court to do. So that's totally different. There's no vindication there. So the court actually agrees with the generality of Ghanaians that if indeed and in fact the Attorney General spoke in the manner that he spoke to Richard Japa in the tape conversation, that constitutes gross misconduct, or professional misconduct. And the judge, in the words of the judge, is quite reprehensible. But she lacks jurisdiction to do any of the things that they were asking. The court, the counsel for the accused persons were asking it to do. So that's a different thing. I don't think that is vindication.
And it seems he's taking the moral high ground. In fact, saying that traps have been set for him, that there are people who are engaged in deception, manipulation of facts, and distortion, misleading the publics, and they are the ones who have been shamed in court. What do you make of his entire conduct throughout this?
No trap has been set for GODFRED Jabua Dami, the Attorney General of the Republic of Ghana. He set his own trap and fell into it. Because, seriously, yes, there is no rule barring the Attorney General from engaging an accused person. But there are procedural requirements to be complied with. One, if the accused person is represented by counsel, you must engage the accused person in the presence of counsel. Two, all engagements must be transparent and above board. Must be above board. Because the rights, liberties of the accused persons are at stake. And an attorney general is enjoined by practice, by convention, by the Constitution to respect the rights of the accused person. That is why a fundamental right is a right to be presumed innocent until a court pronounces otherwise. So if it is the case that the Attorney General was quite interested in the conviction of the first accused person and was motivated to engage the third accused person to procure evidence to be able to convict the first accused person, that is wrong. And he set a trap. He set a trap. Why? He has forgotten his ethics rules. There are things that simply lawyers do not do. And if you do them, in practice, they call you a sharp lawyer. And he knows what a sharp lawyer is. Sharp practitioner.
A sharp practitioner?
Yes.
What does that mean for those of us who are not lawyers?
Those lawyers who are engaged in shady deals, shady practice.
Oh, okay. Alhaji, let me conclude with you by asking, what will his continued stay in office mean? Because the judge cautions about protecting the judiciary and also
so
public
the judge
confidence.
was quite interested in restoring the credibility of the office. Also, putting it beyond doubt that what has happened between the Attorney General, GODFRED, and the third accused person will in no way affect the evaluation of the evidence, the facts, and her judgment. Now, the cloud surrounding the Attorney General will continue to be present if the Attorney General is seen in the case. And so it was the considered view of the judge that the Attorney General could stay away from the case and allow his deputies and the senior state attorney to prosecute the case on his behalf. That was an advice. I've since read GODFRED's response. He says he's not going to abide by the advice.
Alhaji, thank you. Thank you for speaking to us.
You're welcome. But there are legal jurisprudential issues even in that advice.
Okay.
Article 88, when you read it, it talks of the office of that. The criminal prosecution should be initiated or shall be initiated in the name of the Republic and conducted by the Attorney General. Not so?
Yes.
So there's an Attorney General, even though the Interpretation Act says Attorney General includes Attorney Generals. But we have only one Attorney General in Ghana. Okay?
Mm-hmm.
So if an Attorney General is removed for a case, is it the Attorney General or all his criminals or all those people he goes with, are they those removed? Or is it GODFRED?
Okay.
Because there's only one Attorney General.
Okay.
Any other matter, any other person who is prosecuting the matter shall be prosecuted in the name of Attorney General.
I see.
So I'm sure the lawyers are looking at the ruling of the court and to see what to make of the ruling.
So the real meaning of what the judge said would have been to say, resign.
Resign. Go.
Leave the office.
Leave the office. Let them appoint another Attorney General. And that Attorney General will, in the eyes of the provisions of the Article 88, will be properly constituted to do the case.
Alhaji, thank you.
Okay.
Alhaji Inusah Fuseini is former member of Parliament for Tamale Central. Please deal with that. I have to bring in Honorable Kesalatov. I don't know why. Honorable George Kukuriki Segan, I apologize sincerely. He's member of parliament for Cape Coast South.